Hello. Uh, thank you for thank you for joining me. My name is Elias Munsha. Today is a very good day, and so I'm very happy to come live. Please share with as many people as you can. Let me see whether I can share this with some. But I think what I'll do here is I'll also try to come live on a different connection here. And the reason is Facebook is still misbehaving. Believe me, Facebook is still misbehaving. And so that's pretty bad. Okay. So I'm going to come live. So I am coming live on two platforms. So I'm coming live on two platforms. The first platform is my usual way, and then there is another one which I'm using here. And so I'll be looking at two screens. So when you see me like I'm looking at two screens, just know that that's what is happening. Okay. Try to share with as many people as possible. We have a lot of things to discuss today. And if you can get a pencil and a notebook, why not? Because today is going to be a lecture. Today is the day of a lecture. We are going to do a lecture today. You know, the reason is I want to, because you receive free legal education from me. Some lawyers are not as generous. They will not tell you some of the things that I tell you, but you people receive very free legal education. So today you're going to be getting some free legal education because we have to explain a few things that are very important to the subsistence of our democracy. Very important. Okay. I'm going to try and share using the Munsha Law website or the Munsha Law page and share it onto my page and see whether it will make any difference. Okay, let's see. How is that going? Okay, I think we'll get there. Anyway, so the where I want to begin my discussion today is very basic principles in law. And the reason why I want to start very basically is so that you understand the implications of what has happened with President Lungu sending his report, okay? Sending his report to the Director of Public Prosecution. And so that's the reason why we must begin with very basic information, very basic things. So that we can see why it's bizarre that President Lungu has sent his so-called report to the Director of Public Prosecutions. Okay, so today I want to talk about the standard of proof. Okay, the standard of proof. It's very important, and the reason why the standard of proof is important is because you're going to see when I tell you about the standard of proof, you're going to see why it is so bizarre that President Lungu has done what he has done. Okay, standard of proof. Okay, and then you're also going to get some very boring principles. You see, sometimes I don't like discussing very boring things because they are boring. But anyway, it's because you want to get it. So that's why you always come to my page, ask me questions, insult me a little bit, and confuse matters. So I'm going to take you very slowly. The reason why I became a lawyer, in Mubukote. So I'm not one of those young lawyers whose only things that they've done is law. Law if I experience lawyer like me, you see? Because when you do that, you have a very wide experience from which to draw a lot of things, right? Your experience matters a lot, and your knowledge. And so I'm one of those lawyers. And then when you are already a lawyer, you become a little bit much more gracious in things. You stop complicating things that are even clear, And so that is the kind of duty that I've come for as a lawyer. I really look at myself as somebody from Chiwempala, from Milenge. That's it. So all the knowledge I have, all the training that I have received as a profession, is because of that. Anyway, so the standard of proof. Now, when we say proof, what is proof? Proof. You want to prove something, right? So you want to prove something. We lawyers, when we were saying about you want to prove something, there isn't one standard of proof. There are several standards, right? In law, there are several standards. And so you could be looking at the same issue, and yet that same issue might require different standards depending on what the question is. Okay, so I'm going to begin with what I call garden lies. And so when you are chatting with your friends, okay, you are seated together and you are chatting, you are taking lutuku or katata or whatever you're doing, right? And then your friend starts telling you a story, okay? So when your friend is telling you a story, you're not demanding proof. So they begin telling you a story about what they did. You're not demanding proof. And everybody knows that when a person is telling you things while you are drinking lutuku, and so if you are demanding proof at that point, society can't function like that, because society does not function on strict proof on everything that we ever experience. No. That's why muchibemba tulanda okuba ati iliya shirya pansaka nimusenda chipuba, meaning iliya shabantu ngo balelanda pansaka uwasenda pokona kalimo chachire nishe chipuba. Very important. So there is that first level of proof, which is just basic human experience. Nobody pays attention to it. Nobody takes anything seriously. And so pansaka pa iliya shirya bufi. So pali veria shtia bufi, pali veria shtia ma 2 meters, 6 meters, iria shtia kovata vaume, vaumyava. You see? So iwengo you let's observe ule umfwefu abantu barenda pansaka, kuba careful so that you don't take what they are saying as if it were the truth. All right. That's the first level of proof. I call this standard the standard of lutuku, or the standard of insaka, stories that people talk when they are with friends. This standard can also include garden lies. By garden lies, I mean umuntu arefu agero. Abantu garefu agero. Sometimes barata mpokulando tuntutomoto tetwachine sana. You understand that? And even gelo is not holding the guy to strict proof of everything that they are saying. Okay. That is the standard of proof. So that is the basic standard of proof that makes us survive every day. Okay? Lutuku kind of proof, insaka kind of proof, garden lies. That's the first one. Okay. Now we are going to take it up a notch. Very important. Have you seen? We started with stories that people talk when they are insaka. Okay? Nobody demands strict proof for that. But anyway, you take it and you appreciate it and you move on. Then we go to the next standard. This is very important. Now, this standard is sometimes used in, I'm a child welfare lawyer, a child services lawyer, okay? So we use it, it's very much used in child services. So this standard, particularly when somebody is making an application for initial custody, when the government wants to take initial custody of a child from a negligent parent or from a parent who the government is alleging cannot take care of their child. Okay, so when you go to make an initial custody application, when the government is making an initial custody application, there is a different standard of proof. So it's not very strict, right? It is where somebody, just a government worker usually swears an affidavit and says that I found this child was in danger. And this is what I saw. I found that they had marks on their body. I found that, they were being abused or something like that. So I took the child away. And as a result, we want to ask you as a judge to give us what? To give us initial custody for maybe 30 days or 40 days while we sort out this issue. So that is the second standard. So that standard just goes by affidavit. You just put it in your affidavit, and the judge looks at it and says, okay, it makes sense. I'm going to grant that application. We are going to take, the government is going to take initial child custody. That is the standard. Okay? There are several standards. There are a lot. I'm building it up. Remember, we started with garden lies and lutuku. That's where we started. Now we went to this other standard that is used where just reasonably suspect, okay? Reasonably suspect, that's the one. Reasonably suspect. I reasonably suspect that a child is in danger, therefore I'm asking that the government takes over. That's the proof. Okay. The next standard is the standard that is used when the police are arresting a suspect. Very important. So we've taken it up a notch. That standard is known as reasonable suspicion. Reasonable suspicion. So what is reasonable suspicion? It's a little complicated, okay? But that is the standard that the police use. So when a policeman is arresting a person, or if it's a private individual who wants to arrest a person, they go by reasonable suspicion. So what is the reasonable suspicion? I reasonably suspect that this person has committed a crime. Reasonable suspicion. That is what the police use to arrest. Okay? So the reason why they say reasonable is a little complicated, and there is a lot of case law about what is reasonable. Okay? So for example, it would be unreasonable if a policeman wants to arrest you, for example, for carrying dagger in your pocket. But instead of searching your pocket, this policeman goes and begins searching your house. You see that? That's unreasonable because there is no connection between the dagger that is in the pocket and the house. All right? So this suspicion must be reasonable. The other thing is, a policeman can't just come into a store, for example, and then just suspect a person on the basis of how they are appearing that they've stolen. Okay, that's not reasonable suspicion. Reasonable suspicion is if you suspect truly that somebody has stolen, that's when you arrest them. So you don't just go to arrest because somebody appears. That's unreasonable. Okay? The reason why we need to get this very correct, as far as the police are concerned, the reason why they're using this standard is because it has consequences at the end of the day, okay? When you go to a court and a judge, if the police had no reasonable suspicion why they arrested a person, your client walks if you're a criminal lawyer. In other words, reasonable suspicion is very foundational to a criminal charge. Reasonable suspicion. All right? So, police, that's the standard that the police use. And the policeman, in fact, who is arresting you must swear some form of an affidavit. Now, the language differs. The principles are the same across the Commonwealth, but the language differs. In some jurisdictions, it's known as an information. In some jurisdictions, it's known as a docket or whatever it is. But there's got to be a document where this policeman says that I found this person, that this person committed a crime, or I reasonably suspect after my investigations that this person committed a crime. All right? That is the standard. And then there is a different standard, okay? It's an administrative law standard. It's a standard found in administrative law. Let me tell you something about this. For example, if a president, because a president is chief executive of the executive and the republic, so he has what is known as an administrative law power. Using his own discretion, and his own powers as a president. So he can say, today I want to get a report on such and such a matter from this individual. All right? That report is covered under executive privilege, and mostly it's part of the administrative process. So, okay, so there is this issue, bring me a report. When that report comes to the president, it's not a criminal law report. The reason is the president cannot making decisions on the higher standards. I'm going to come to the standard of the criminal, because what you need in that report, sometimes the report includes he said, she said. Sometimes it's suspicions of the writer of the report. Sometimes it's the professional opinion of the writer of the report. And the president must have that power to summon reports at any time. He's the chief executive of the country. He can do that. And I think that is what happened with the shooting report. It was part of his administrative role. When we say administrative, we are not talking about the secretary and other administrative duties that we do. Now, I do administrative duties in my law firm. That's not what I'm talking about, okay? I'm using this word administrative in the sense of an area of law that deals with how institutions of the state govern the people, okay? So that is an administrative law function. And so the president requires a report from one of his subordinates to present him that report, okay? That is what happened when he asked the chief police officer to give him a report about the shooting. All right. And that report is not a criminal report. It's not a criminal report. It's an administrative report. That's why he said, I want you as Inspector General of Police to give me a report about the shooting. The president did not say that I'm instructing the police to open a docket so that they can find a person who shot. Very different. Extremely different. Okay. So that is a different standard. So if that report is going to have all the information, it's going to also have operational details, like which guns, what and what. Operational details that are quite inconsequential to other things. Okay. Then there is another standard. It is known as the standard of balance of probabilities, the standard that is used mostly in civil matters, balance of probabilities. Okay, that something probably happened. That's a different standard. Standard of probabilities. Standard of probabilities. It's very important. That's what happens in civil. So if you're do not think that when we are trying to object to these things, there is a reason. So this is the reason. So as the balance of probabilities. The balance of probabilities, a standard courts yabonfia in civil cases. Civil cases, what are civil cases? Civil cases such as umuntu wasakuchita sotu wali mutuka. You know? So ngawatuko umuntu ero akushitira Simon. There is a different standard that is applicable. Balance of probabilities. Then when a docket is opened, police aikato umuntu ero achita open docket. Remember, police ngaisula docket alebonfia a different standard, which is reasonable suspicion. Very important. Reasonable suspicion. That is the most important word that the police are trained to use. Reasonable suspicion. Constable the people with lower ranks. It's only higher up ranked policemen. Yeah. That's why even lower ranks, they defer to the police officer in charge. That is what the law in Zambia says. I'm a police officer in charge. Certain crimes. No good to investigate. Okay? So the person who actually investigates and arrests a person is known as an arresting officer. An arresting officer. Very important. Arresting officer. Okay. Let's move over. When the police have investigated and have arrested a person, they arrest him on reasonable suspicion. However, when they take the docket to the Director of Public Prosecution, the Director of Public Prosecution uses a different standard to decide whether they are going to prosecute or not. A different standard. So it is not the standard of reasonable suspicion. No. The prosecutor uses a different standard. What is this standard? It has two elements to it. Two elements. of the prosecutor's standard. The first standard is there reasonable prospect of conviction? That is the first standard. So when a prosecutor is deciding whether they should go ahead and prosecute this docket that the policeman has brought to their attention, their question is there reasonable prospect of conviction? So the standard changes from the police, which was reasonable suspicion, to conviction. The prosecutor begins looking forward to a conviction. The policeman was arresting to stop crime, and then takes the docket to a prosecutor who must decide whether there is reasonable prospect of conviction. That is test number one for prosecutors. Test number two is known as public interest. Public interest. So prosecutors must decide whether there is enough public interest to prosecute this case. There are instances where, when prosecutors are deciding to prosecute, even when they don't have reasonable prospect of conviction, if the public interest is so much greater than the prospect of conviction, they're still going to go ahead and prosecute. In Zambia, what has led to this situation is one thing, okay? Gender-based violence and defilement. So mostly, when these prosecutors receive a docket on defilement, they usually go ahead to prosecute, even when they know that there is very little chances of conviction. They do it because of the public interest, because the public is interested in ensuring that all defilers are what? Are prosecuted. Public interest. A public interest also involves the interest of the government interest. Very important. Public interest. For example, if now the prosecutors are independent from the politicians, they're supposed to act independently. That's why the Constitution, Article 180 of the Constitution of Zambia, and I think the National Prosecutions Authority Act, they say that the Director of Public Prosecution and her officers, they have independence. They cannot be controlled by any other body. So they have got to make their own independent analysis. However, that independent analysis includes an analysis of public interest, even when a case involves the executive. Now, I'm going to give you an example of one such instance. Let's assume, Zambia yatuma ama bashushushu, okay? Zambia yatuma bashushushu kuisa. Which country can I give an example of without causing much problems? Malawi, okay. So Zambia yatuma bashushushu ku Malawi. Elo bashushushu baya filufia ku Malawi babekata. Elo na ifo ku Zambia to such to realize that na Muzambia mwine mwali bashushushu ababena Malawi. You know what I mean? Okay? So babekata. So our shushushu in Malawi babekata. Na ifo Muzambia abashushushu babena Malawi to abekata. So that issue then becomes an international incident. Okay. Let's assume that what is the offense that these shushus have done? Maybe murder? Can we say murder? Okay, so they're hidden, they commit a murder, and then the secret is out. Malawans know and Zambians know, but it's our shushus who committed these crimes. Our Zambian shushus committed a crime in Malawi, and we and Malawan shushus came and committed a crime in Lusaka. All right, it's an international incident. Okay, what is public interest there? The Director of Public Prosecution, because the Director of Public Prosecution is independent, it means then that she can go ahead to prosecute that Malawan shushushu. All right, public interest. So she might ignore it and say, no, I'm not going to prosecute this. I'm still going ahead to prosecute this. And yet the interest of the government is that they drop the charges so that their friends in Malawi also release their own shushus. Okay? So if there is a conflict, then the government's lawyer, because the lawyer for the government is known as an attorney, the DPP refuses and advise the court to Kwebati, because there is this issue of public interest. This DPP is not following our interest as a government, because we have what? We have a part and a role to play in this confusion. So number one, court, please acquit this person, because if you don't acquit this person, it will be something that is going to implicate the international relations or something like that. Okay, so that is an example of public interest. So that is what a prosecutor does. A prosecutor evaluates everything that is presented to them on the basis of reasonable prospect of conviction, and the second one is public interest. Okay, now when this matter now makes its way over to a court uses a different standard. Very important. It uses a different standard. It's known as beyond reasonable doubt. So have you seen how the case was building, right? So it's starting to build from reasonable suspicion. And then as far as prosecutors are concerned, they are looking at it from a reasonable prospect of conviction and public interest. When this docket shows itself before a magistrate or a high court judge, criminal division, in order for you to convict this person, you must prove your case beyond a reasonable doubt. Beyond a reasonable doubt. Which means then that our system is like a funnel. Is it a funnel or a tunnel? It goes like this, right? The standard starts very low. So the standard starts with reasonable suspicion, then it builds up. By the time that it is going to a judge, it must be beyond reasonable doubt in order for you to convict a person that you've accused of a crime. Beyond reasonable doubt. Every step that is taken from the time that somebody is accused of a crime, questioned by the police, investigated, and charged, all this process is part of what will happen at court. So conviction in court has very little to do with what actually happened. This is what you need to know. A conviction in court has maybe 20% to do with whether somebody actually did a crime. 80% of it is about whether the police followed the law when they suspected this person of having committed a crime, when they questioned him, and when they investigated. So if you are defense lawyers spend 100% of time interrogating process. Okay? They are interrogating process. They are not interrogating whether kantwa agana. That's not what they are interested in. Every defense lawyer, it's process. Okay? If you are a policeman, you say that you have arrested this person. How did you make up your mind? They're known as arresting officers. They take the stand in court. I don't know, defense lawyer, mwemba. Katuishiba ambia defense lawyers mwakwata. But nena ishiba mwemba. I don't know ipu show you arresting officer. Ati what happened? Charishane. What made you decide that this person had done a crime? Very important. So that arresting officer is going to say, I was in my office, then I was informed by someone, and then I decided to investigate. And after I investigated, I then made up my mind that there is reasonable suspicion that this person had committed a crime. And then what happened? I took the docket to the prosecutors. And then the prosecutors, that's why we are where we are. Oh, what happened when you were questioning this gentleman? I questioned this gentleman in police. He had access to counsel. Did you tell him to find a lawyer? Yes, I did. He declined that thing. All right. If you, as an arresting officer, you do not take care to advise the people you are questioning of their rights, the client can walk. Okay, the person that you've accused can walk. All right. So those are the different standards. Now, let's go to what the president did. Okay. Now you get all the idea of all these complexes, right? Now, let's go to what the president did. So there is a shooting in Lusaka. And in this shooting, everybody has this common understanding that this shooting was done by the police. Everybody. Also, why pusha kulusaka bala kweba abashutire ibakapokola. Ero na inena esalunda ponje vere actually. Icho bakapokola bashutire. Nicho bali bapere polo kuli ni balungu eba tumine bakapokolo kuyayipa yabantu. Ayin, bantu balungu eba ishitefi futi bashita nempolo bashita nama armored vehicles na manda bashita ni balungu. On that day, it was a pre-planned operation. That was not a riot. A riot is something that just comes suddenly. It's the plan we know. Ayin, nefma armored vehicles. They were all over Lusaka. Echo inendanjiro kwebad. Abachire plan ya operation yakuipa yabantu nibakapokola na balungu eba batumine efyondandane ati ni balungu baipa ya. Okay. That is public information. That is Idiashija Pansaka. I'm entitled to my own opinion. Now, President Lungu then requests what is known as an administrative report from the police. Now, the police give him that report. Now, the public is interested to know, right? But he says that he received the report and then he has forwarded that report to the Director of Public Prosecutions for attention. The only problem is the Director of Public Prosecution is not President Lungu's legal advisor. If the president has a legal questions concerning that report, he should not have taken that report to the Director of Public Prosecutions. The Director of Public Prosecutions is a prosecutor. Some of you are telling me of Article 180 and the National Prosecutions Authority Act. And you're telling me because the Act says that it is the Director of Public Prosecutions' duty to institute and conduct prosecutions. Institute and conduct prosecutions. By the time that something is becoming a prosecution, nishi, the first process has already been done. The DPP is not the first person. It's not. They are not an office that faces the public. They are not. Uzambia mwalimu hapo at press conference by the DPP. This is more at DPP public relations office afumia a statement to the public. No, they are not public facing. Okay, ama statements mufwa kuliba kapokola. It is the police. Abalando kobat oyu na tumuikata for this. Oyu na tumuikata for this. Eroto watu wala docket kwisa kuliba DPP. So this idea yeah kobat ba president and an administrative report, la Director of Public Prosecution has several questions. The first question being, if that is an administrative report, what the honeybee will the DPP do with it? Okay, maybe could cover later na signature na abachaya po signature pantu. Pabantu abachaya ma signature Zambia. Lungu ni number 1. Bali ba signature. Na bachaya po na signature. So batulange, what are the instructions to the DPP? If, for example, if the president says that Batwala report could DPP, then it gives you an indication that they are looking at criminal charges. Because the DPP is not a general advisor of the government. No. The government has their own lawyer who is known as the Attorney General. The Attorney General does not only represent the government in terms of civil matters. The Attorney General is the lawyer for the government on all matters, beginning from civil to every fiancé. It's the Attorney General who is the government's lawyer. If the president wants legal input into the report, he should have taken that report to his Attorney General so that the Attorney General gives him the advice that he needs. This idea that the Attorney General is somehow just restricted to civil matters. No. If the government of Zambia is a person, The government's lawyer is the Attorney General, not the Director of Public Prosecution. So if the president sends this report to the Director of Public Prosecution for attention, it means then that maybe the president has some criminal things in his mind. If that is the case, think with me like you are a defense lawyer, okay? Somebody is accused of committing a crime and then you are in court with a prosecutor. And then you ask them, you prosecutors, what happened? And then the prosecutors, because the prosecutors are lawyers, the prosecutors are not witnesses. The prosecutors call the police as their witnesses. That is the procedure everywhere. The arresting officer is summoned by prosecutors to give evidence on behalf of the prosecution. So what will happen if at all any person is charged? You see the confusion that President Lungu has created. Let's assume the DPP decides that, okay, I'm going to prosecute this matter. And then you are the defense lawyer. This is what you're going to say. You're going to say, dear prosecutors, this matter, you investigated it yourselves. This matter, you got it out of a report that came from the president. Therefore, my client is clean. Why? Because the procedure that we have under our law, that starts with reasonable suspicion and then goes to a higher standard of beyond reasonable doubt, has been confused. Right? It has been affected. And that is the reason why, if there is any issues, if there are any issues that are involved, that's why now, here's the thing. The Zambian public is not just interested in the criminal side of what happened with the shooting. We are also interested in the governance side and in the operational side. The president should not hoodwink the people of Zambia by saying that na tumachi report kuli Director of Public Prosecutions, because a conviction, a criminal court conviction, is very difficult. Beyond reasonable doubt. Number, there are several things that we need answers of from the things that happened on that day. It was not normal. It is not normal for the police command to release armored vehicles to arm the police with ammunition, live ammunition, to go and shoot at the people of Zambia. Secondly, nokushita fi manda so that ngavashuta baipaya batola nechitumbi basenda. Those are kind of the questions that the people of Zambia have. It's not just the criminal side of saying the Director of Public Prosecutions, but they prosecute a crime. Because under the circumstances, under what has happened here, there will be no conviction. Which judge is going to convict? You tell me. Defense lawyers right now, they're all over. They're like, whoever is in that report, Ngaya Bachita hires defense lawyers. Their client works. So when we say that, you see, umuntu ngataleteka wino, ne feel straightforward, feel about complicated for no reason. Ebwafya waba Lungu, ebwafya waba shikadongo. Pantu baleteke fya madongo dongo. So ngoleteke fya madongo dongo. Ne feel straightforward, feel mboku ba complicated. If it clear, feel mboku ba complicated. Why? Because ulete tauteka wino yo. So this is just one of the symptoms of the lack of leadership from State House. Pantu, if you are saying that now what the report, you either make some of the findings public so that abantu abali interested in what happened on that day. Vaishiva, fyachitike. Twakwata kwa idea. Not to rera ndafedia shijamulu tukuna pansaka. You understand that? So kulandako. Okay? Ninkwata report, ninkwata ma suspects. Twaishiva. Number reporting it is secret. Elo number watu weba atina twala a secret report to the Director of Public Prosecution. Elo Director of Public Prosecution takwata obligation to the public here kubata kuti I am kuchita press conference. Elo number balondolo la what is in the in the report. If you took because Director of Public Prosecution, remember, information that comes to her, she judges it on two standards: public interest and reasonable prospect of conviction. So, number ngatakudi any of the evidence from the criminal side and reasonable suspicion. What will the Director of Public Prosecution say? There is no reasonable prospect of conviction. That's all. Which means then that the president is using a private report from his office where he has executive privilege. Because the report, you can't report on it. It's covered by executive privilege. So number, I want for executive privilege. Ukulembachi report the Director of Public Prosecution. Act. Act. What kind of acting is this? Imweba PF, mweba ntoka, munje. Ati yo munsha, you are not a lawyer here. These are things. Mwipushe na ama lawyers mu Zambia, ivinderanda, bari fishi, batabamieba fie pantu, bamtengo. Tamulipira. Efe tabamiebela. Why should the lawyer tell you all these things? If you are free? No. Ineneo mieba fie if you are free, ineneo. Pantu na fuma kuchwe mpara. If you're FFF. Otherwise, why would they tell you these things? If complicated, if you complicated. Imwe, tafia ba complicated if yo. If you ba lungu bareteka, tabareteka bueno, yo fiama dongo dongo. Fiama dongo dongo. Number, today in Parliament, mumfo number how, when people are lying, the Minister of Home Affairs, Pyongo, he was saying a statement. He gave a statement. And then palast, a statement Pyongo, it's not only the report that has gone to the Director of Prosecution, even a docket has been sent to the Director of Public Prosecution. It's either Kampyongo is lying or he has no idea what he is talking about. Okay, by the time the docket is going to the Director of Public Prosecution, okay, now police can open a docket on anything. It's known as an open docket where now a crime happened, but you don't have a suspect, right? So it's open. For example, Mwasango Muntuna Bepaya. Okay, now this is not natural cause. So the police open a docket and then they begin investigating. Now, they can't take that docket to the Director of Public Prosecution. The reason is Tabakwete an accused because the DPP is a prosecutor. In Zambia, if a DPP, Takwata, other administrative law powers like in other jurisdictions, Takwata is a prosecutor. That's her role. She can't come up with an inquisition at inquisition. No. It's other institutions that those powers of investigation and inquisition. The DPP does not have the power of investigation, even funding. It's restricted to prosecution. It is not investigative in nature. Unless there is a specialized body, your government, force of corruption, okay? It was an executive creation, fuse ama investigators nama prosecutors, you know? And history will continue to debate whether that was an appropriate way to do it. All right, the task force on corruption. And the major legal battle that was taking place for that was how that it blurred between a prosecutor and an investigator, like Mutembo Nchito. He was doubling the same. We understand that he was traveling to UK to go and investigate. So that has its own confusions. But anyway, that is the issue of what is happening. Okay. So, so Admun Shaiwe, you are not a lawyer here, so that we fish if you nama lawyers Mzambia ba ishiba. No kumyebeche saba myebera. Nicho tamubadi pira. Kutemwe if you are free. Which lawyer is going to spend all these hours? Are mirondo redef? No. Number two, if you say if you amafunde yonse Mzambia, I'm at 45 minutes. The whole legal infrastructure in Zambia, yabasungu. The roles of Director of Public Prosecution, the role of Attorney General, Executive Privilege, Administrative Law, Constitutional Law, all these vyabasungu. Ebene. So you can't shut me up, no, because I'm not a member of the Zambian bar. I'm not a member of the Zambian bar. Very important. What that means is I cannot appear in a Zambian court to represent a client. To represent a client. I can't do that. However, the legal infrastructure of Zambia is common law based. And it comes from the English. Everything. So imwe tetimwalufiania mwafichita confuse ifintu ifyo kateka achita elo nomba mwanje bati munshawilanda po pantu yoni we boloya wabasungu no nine lawyer wabasungu na asumina nine lawyer wabasungu na asumina it's true nine lawyer wabasungu nomba iyonse legal infrastructure twako hata ku Zambia yaba nani te yabasungu mwevo te yabasungu ifo fwe ma lawyers babasungu nife tuwashire amafunde nife tuwashire constitution nife tuwashire criminal procedure nife tuwashire ama judges nife ifo fwe ma lawyers babasungu legal infrastructure ya ku Zambia yesu so nomba tete mwabule efunde mwafifulunganya ero mwalanda titwirandapo no Zambian lawyers tete balandepo sana necho tete balandirepo nicho tabeshi who they are offending nomba inaido kainge nebo lawyer wabasungu so kuti naisa muri situation ifire nalandapo nalandapo njebere vifyo barechita balungu tabareteka bwino yo I can freely do that, but I know several other Zambians who would like to talk about it, but tabalandapo yo mlandu bare ifyo fine evichitika efyo ndandirapo ain my first degree is from England na amafunde ama rules to bomfya ku Zambia high court rules Supreme Court rules ya ku England eko nebo nasambirire to have my law degree fya ku England nomba te fyandi fya ko bat nomba na sungiri that you fyandi no I come from Chonpara. We are very generous people gawasambirira you have a duty kwa fuirisha ko ba munongo okubalondorere fintu fire chitika nefyo abantu tabareteka wena wabalondorwera I have no interest in any high offices that you are aspiring for something big aspirants efe bamoneka fino no kulanda efe balanda fino inen fwa yokulandira kwa balanda banandi you can take positions or anything like that I don't care inen defwa yokuchite okulandira kwa abantu abo bapela afima condom ifi yabola epela ebondantira ko fe that's the only passion I have it's to speak for the weak for the poor for those who cannot speak on their or by themselves bali ababepa ebondantira ko fe nebo bantu nganadi wakupfuwa yati yo na inentekeko kanadi amboku ukuichenchenta bwino restrict what I say shan everyone balando ko batbunsha udifye bwino walisambire no matetu wa chef yako pakanwa chebere no tetin chef yako pakanwa bantu balungu bali bule futi lempolo babika ero batuma bakapoko ko ya mkushu abantu ero inenchitejana njikale ati yo mkwai chirifye bwino ngabaipya ati nani washutire ati yo mkwai nitude tukapokola tuwashutire iyo tude tukapokola batu tuminefye kuli balungu ni balungu abepeye ni bakateka efyo nomba kanshi apo baipa kuchita confuse vintu nefiri straightforward fyonse fyaba confused ifya ko bati ngabachita kantu tabachita fyo tuntu tuli very straightforward yo kuchito tuntu to ko bati it's complicated bachita kantu mwaipusha mwebere what is going on here kuli abale posta pati yo what this means is inquest shani ala mwebaome ni mwebu teko tali mfumu aba clear fm lechita ni mwebu lechita tali kuba clear ko bati ifunde twabomfia when we are doing this needy not abantu bamboko kuchita speculate mwumva. So eriashi ine am just ndanjira kofia abantu enchito yandi ebuite bwande nakumuru ngati wafwa pandu bonse tukafwa so kanji kumulu kunga nafwa therefore eresa ngaya njipshat what did you do nika mwebati yo mkwaya I had 7 degrees. I was a pastor, theologian, political theologian, lawyer and fiancé. No. Therefore kulando kobati I spoke for the poor. That's it. I spoke for the poor. Iryo balungu bavulile mfuti ukushuta abantu nalilandira kwa abantu abalanda. When honey be supplied, if ma condom ifiyatulika nalilandira kwa abantu. Iryo babatumina mapana dwayabola nalilandira kwa abantu. Epera. Iryo buteko bwale ibe mpia no kuchita efintu ifya madongo dongo nalilandira kwa abantu. That's my passion. Ayenivane twashako a few minutes a lecture yarero ya shupain ime mweba ko teba nandi mweba fwa yoko chitalo go ahead elongana mwali kwata kona disposable income just enroll abana benu nilesa kabasunga imwe first ngale extension chiteni ko law there's nothing wrong with it steni ko law no kulaisa kuma live broadcast yani because ndamifunda law for free. Sikana, I'm also studying law, post my other qualifications. Exactly. That's what we need. Kulium nenso mopa Twitter leipshet no ngana push a law degree. If I started it now, I'll be 38. They will be 38. I'm like, go for it. Go for it. Pandubu fibuachira. And then even when you are studying law, you see, when you are studying law, you need to be very broad-minded, extremely broad-minded, right? Extremely broad, not narrow-minded, because you can't study law like that. You need a broad mind, broader reading. Waliberenga kofimbi ero nomba wa mukochita law. Because if you akashamba tuambiko stele wanikale ba mwana wasa. Ukobati we mwana wasa, you lack appreciation of the arts. Akashamba tuambiko stele wani. Evere iwe mwana wasa. From grade 12 straight into law school. So if you're mona life, you'll have mona life in terms of law, son. But you need a broader perspective, to understand the spirit and the philosophy of law. Very important. In the law school I went to, of course, in England, I think one thing I appreciate greatly is the broader perspective, to the philosophy of law. What makes law law? You understand that? That's very important. Okay? What are all these different doctrines? Before you even read the letter of the law, you familiarize yourself with the doctrines. How have we developed to be where we are? That was the fight on Bill 10. It was the fight about the philosophy of the law. What do we want in our constitution, right? That is what it was all about. Anyway. I'm searching Madam Imboela's house for defamation. Defamation in bedroom, which is pretty sad. Okuya tivaka pokola. Bapoka na warrant. Again, kainge, a magistrate must give you a warrant before taula ya munganda ya muntu. Okuya mugochita search bedroom ya muntu. Ativarefu ayo kusanga defamation. No wonder you are a pastor. Mwandi, everything wandi law. kwali baba mu abanje oko bati yo ninshi as a pastor ninshi wachisilo njebe imwe kainge calling ya muntu ikulu, it's not small yako bati mwachita restrict umuntu ati yo mkwa iniwe bofe pastor, that's all you are. No, refuse that. I'm a pastor, I'm a theologian, I'm a lawyer, I'm a via jala lundeni po fiancefi ati ushomu kalipali ba Elias Munshana ba Keith Mwemba to interpret the law ni banani? No, Keith Mwemba bakati. It's not really that I have very no. These are basic things. If you don't know law, they are basic law. Even in fact, you get this from first year of law school. You are broad-minded. Not you know, nangwaba iche 18-year-old alechta law. Tabakwata usually it a broad mind here, but to appreciate things. Under 18-year-olds should not do law. What I'm saying is nishtaula kwata ko different taula bapo disappointed, taula chitapo disappoint, taula, you know. Anyway, any questions here? Okay. Yeah. Thank you. Thank you very much for joining me today. So I know that some of you can use this lecture. No blame Bama notes wino. Next time when your lecturer asks you a question, you're going to explain to them there are different standards of proof, administrative law, shan yuko, and constitutional offense just from this lecture. No, but it's not enough. It's not just one thing. So don't just take one lecture. No kuya mukublete abantu ichongo sana ati yo mkwaina mufisa mbili da. Yo. There is more to this than all this, right? Yeah. Okay. William Leng, I'm getting law courses for free. No. You must go and pay for it. Go into law school or something. With the inquest, no, the inquest is going to be done. It's an independent process. The inquest is independent. They will do it. Yeah, I hope. So the issue is not just about money. You may not have money now, but if and when you have money, please, iyo somewhere on pundu mwape. So when God blesses you with money, wika have mugushita fi motoka. No kutinya sana echipandati na ushita chimotoka. Go and study. Yeah. Now, Anawali have been caught by the police. It's pretty sad. This is some of the things we needed to talk about. Not if you're caught by Kateka, Babula fi report about Tumakudi DPP. Eronombati tuiranda po tufirawe kofie. Mwewa ome. What we need is reform ya baka pokola. Even aba Lungu abe ne bala ndirati you want baka pokola to reform. Fiabo fi. Mama. Inengana nando kwa tababa Lungu tabareteka wene mondosha. Panto, what we need to see is some changes. Not if you're covered, ama enemies, into fighting political battles. It's pretty bad. So who is the problem? Are you going to say it's Vagapokola? No. Lungu eushirete kabwino echalo. Tefio bateke echalo efi. Tefio yo. Tabarete kabwino. If you do law degree and you are not admitted to the bar, of what use would that degree be? I'm sorry. It's okay. You can have when I did my law degree, I wasn't admitted to the bar. And in fact, I don't think I had immediate plans to be admitted to the bar. I started doing my law degree in 2009. Facebook. So I was writing on Zambian law subjects up on Facebook. Some people were even saying Facebook lawyer. Facebook lawyer. So I've actually studied law, graduated from law school, did my second degree in law, went to CPLED, did CPLED, which is the Canadian equivalent of ZIALE. I did CPLED and I got called to the bar right on Facebook. Pretty amazing. And I'll be 5 years at the bar in May, right here on Facebook. Anyway. So yes, you can have a law degree without prospects of practicing. It's okay. It's just a degree. So you can be like a pastor, you can be an engineer, and you have a law degree, or an accountant, and you have a law degree. At least it helps you kuverenga bwino ifintu nokuchefyanya ko so that balungu ngaba mix up ifintu abebati yomkwa ifitafile monek tamuli amano iyo tamuli mano mu tamuli lesa. Are you a law student or lawyer wama politics? Sorry, mreanda na ine nangu mreanda na wambi. Miguna is a Canadian lawyer. He's very wonderful. No, I'm not. Mnaliva humble. Kaing, fwewa kuchwempara tuwaliva humble. So, I don't think so. Enough mavyo kuchwempara. Chapo. Okay. Thank you very much for joining me here today. Rose, I couldn't go without looking at what you've said. Thank you, Councillor Elias, for all the work you are doing for Zambian citizens, to teaching them the law in Mwandin. Na totera. Na nguba tutukeshani tulekonka nyapo. Kainge ifuenzere malumbo. Nomba efe tuibwere mo atwala tutuka tuleke okubombere chalo. Atumula atinish mwalekere okubombere chalo atinsere. Insere should take him fine at yom kwai someone is going to insult tuleke. Kafe bare ipaya okuipaya. It's not play. Vashta fimanda mande fyakoba tinga bakushuta wafwa no kutole ekitumbi batola abene bayashika tuikarefi ngama kondomu aya ninolandako 17 million vaiva ero bayalete finish ama condom aya kwebati nangu kachepe shani kupoleka nangu chikule shani kupoleka ama lab technician bari isa yasenda yama condom babika muamenshi yaswa babika molulenda lwapula ife bane testa yama olulenda muri condom fiapita ne femina na fefene baisha mu condom fiapita ni poison. Condom yako batire pishe femina in the lab no lulenda lwapula muri condom. Mwebo ululenda lwapula muri condom lulenda abantu bafwa abantu balwalo tuswende no tuselena bola balwala abantu ero nomba tiyo twiranda po mwebo ati tutina mukatutuka iyo namuleto ngamulefu okutukana namuleto kana lero okulandira kwa abantu abo mwapere amakondomu yatulika okulandira kwa abo bomfi kumopani okulandira kwa bena Zambia kunchango okulandira kwa bena abalanda banandi kuchwempala ivyo tatwakareke iyo tatwakareke. Thank you very much. God bless you and God bless our country. Mairo tafia bombere pantu nali kukoti na lero nachipa kukoti nomba yachipo bwango, you know, kange due to COVID because ndi quarantine for 14 days. So ture kwatira court pa technology. Ebusumo wako no kontumwe technology. Nga uli mu quarantine kukutumina mwaluburula kumirandu mulelubulwira kwisa pa phone pa webex shani busuma wakufiyalo kuno ayin Na ku Zambia kwine obvious vanhu ninkwata kwa kamulandu ku Zambia nkamieva ivyo chali nkamieva kamulandu aka kare isa mu February. So I hope limbi vakansuminisho ko vati nkalovulwire kuisa na lisaya njevere mwevaume ne loya wa vasungu aleni vane nomba tumfuane evere iwe loya wa vasungu kwi 30 njevere mwevaume kainge ninjisa atawe iwe tuwakukana we loya wa vasungu njevere okay no problem naliva chitaso. Okay, thank you very much. God bless you.